could have.
For barristers, solicitors, and immigration advisors. I have got qualification of LLB and then this is a brief introduction. Now we're going to move forward about the course of contents, and this is how we're going to move forward. So let me further explain you. The purpose of this lecture is just to enhance the capacity of professionals. And on top of that, whoever is registered in this course, they're going to get certificate to the email within a few days. So this is the whole course of contents. I can see lots of inspiring faces and enthusiastic people here. Do not go from the course structure. I can see that this is quite lengthy course structure, but I'll try my level best to explain you in as earlier as possible in a very simplistic way to make you better understand. So, first of all, we'll explain history of UK immigration law, then we'll go main British immigration laws after 1948, then sources of UK immigration law, understanding the most important rule, which is HC 395. Then we'll go to categories within the immigration rules. Then we'll go to important decision, and which was early decision. The impact of early decision, then using the immigration rules in practice, all rules and legitimate expectations, and then we'll go to a practical example of pre-action protocols and immigration court hierarchy. One thing is very important, although we have a very long list of contents, but I'll specifically focus whatever is practically oriented with all of you. Whatever you can use in your practice, I'll not bore too much about the history and whatever is not related to you guys. So let's start with the history. It's very important to understand the history, because when we discuss about the UK immigration law, history always matters. Before 1905, there was no concept of UK immigration law in the United Kingdom, because the borders were very open. Anyone would come and go. However, in 1905, the first Aliens Act 1905 has been introduced, and England started putting the barriers on immigrants. And thereafter, we had Aliens Restriction Act 1914. I'm not focusing for a reason about those historical acts, because they are part of history. I'm explaining you because you people should know that they are existing. But nowadays we are not more using. As a practitioner, we all should know that what was the history of UK immigration law. And then now British Nationality Act 1948. This act is very important because, as you know, that there was a world war in 1947. Lots of countries got independence from England, especially India, Pakistan, and lots of other countries. So England have started taking seriously to the immigration law in 1948, and then we had British Nationality Act 1948, then Commonwealth Immigration Act 1962. Thereafter, we had Commonwealth Immigration Act 1968. Very important act which I would ask you to focus, and that is Immigration Act 1971. We are in 2025, but till now, we refer Immigration Act 1971 because it basically ended automatic right of settlement for Commonwealth citizens. I would suggest you keep in mind this act, Immigration Act 1971. Then British Nationality Act 1981, this act tells you how to apply for nationality, how to apply for settlement, this and that. Then Immigration Asylum Act 1989, 1999. Then we have Immigration Asylum and Nationality Act 2006. This is 2.7. I would suggest you keep focus on this act as well, because lots of people, after entering into the UK, they apply asylum, although it's quite a big issue nowadays. Every second person who is entering in the UK applying for asylum. I personally, as a practitioner and as a tutor, wouldn't suggest you to go to this asylum in every second category, because we have got country guidelines. Pakistan is a stable country, and every second asylum always creates a bad impact on the identity of a country. Then we have Immigration Act 2014, and then Immigration Act 2016. So these were the acts which I tried my level best to cover in a short span of time. I never wanted to cover and bore you. I can understand they're quite boring, but by jumping, we can't understand, because we have a law background. We all are law professionals, and we have developed a habit not to grasp or digest the things which are not logical. Therefore, I explained you. And one thing is very important, as you all of know, the definition of a good lawyer. A good lawyer is not that one who knows the whole law, but a good lawyer is that one who knows how to trace of the law. Therefore, I explained you the whole background of the immigration history. Now, I'd like to come on sources of UK immigration law. Why we are explaining sources of UK immigration law? Because when you have come across any client, any query before you, you should know how to trace out. Then we have sources. The first source is primary legislation. It's Act of Parliament. In every country, Act of Parliament is always the primary source. Then we have secondary legislation. Then we have immigration rules, Home Office guidelines, international convention, and then the discretion of the Secretary of the State. As far as concerned about primary legislation, secondary legislation, yes, they are very important. But the most important thing is immigration rules and the Home Office guidelines. If you go to the Home Office web page, you will find the guidelines. There are two types of guidelines. First are guidelines for the caseworkers, and the second one is guidelines for the applicant. It's very important for you to go through these guidelines, because guidelines want to tell you what are the requirements, what documents you need, and as far as concerned about the guidelines of the caseworker, it will tell you how a caseworker would judge your application. From the sources of UK immigration law, I would suggest you focus on immigration rules and Home Office guidelines. And one thing is let's move forward to the key points to remember. Immigration law changes very, very frequently, specifically in regards to UK. Why they change very frequently? Because when the immigrants are needed, obviously we'll have a relaxed policy about the UK immigration law. And when the immigrants are not required, simple as that, we'll have a very tough immigration policy. Move forward, please. And now, understanding the most important immigration rule, which is HC 395. You'll find that there is not a chronological sequence in our lecture. This is for a reason. I have picked and choose important topics for practice point of view. I picked and choose those areas which are necessary to understand for those people who are new in immigration law practice. Therefore, I have picked and choose. So, this immigration rule, HC 395, basically tells you the requirements for entering and remaining in the UK for those people who are subject to control. I would like to focus again the requirements for entering and remaining. When we say requirements for entering and remaining, you know what does it mean? It means that this rule is going to tell you that what documents are required, and remaining means if you are inside the UK, this rule is going to tell you that how to extend your further leave to remain. As immigration law is a very, very wide category, we have about 800,000 immigrants in the country. Do not confine immigration law up to the extent of entering to a country. Basically, immigrants do lobbying outside of your country. Immigrants basically are your ambassadors outside of your country. Basically, they are your defenders outside of your country. Nowadays, because of globalization, the impacts of globalization have been really changed. The day has gone when you had a very strong type of army and you would win. Now, due to the globalization and different dynamics in a country, we fight on each and every stage. Nowadays, we need a very strong lobby in every country, and those countries which are developed, they always focus. I was reading one day, we had a visa which was called Tier 1 entrepreneur and Tier 1 investor. The UK Home Office has stopped this visa because I was reading that Russia has launched all of their businessmen under the disguise of this visa in the UK. And those people were involved in order to lobbying in the parliament, therefore visa was stopped. Therefore, I would suggest that we need to focus these areas. I know there are lots of areas where people are practicing, especially in civil area, criminal area. But I want the young generation, please focus on those areas where you have high demand, where you can earn respect, where you can earn your livelihood easily comparatively to those areas. Now, categories within the immigration rules. When I was starting this course, I had my colleagues and juniors, they were asking me that instead of boring the whole audience, it's better for you straight away go to the categories. Because most of the people are interested in what are categories instead of boring themselves about the history. But as I told you, for a reason, history has been included. Now we have these categories under the immigration rules. The first category is protection route. The second is visitor. The third is students. The fourth is workers, business and investment routes, and then family migration routes. And there is something which is called outside the immigration rules. Let me explain you what is outside the immigration rules. The way we have discretion in Pakistan before the judges, you know, when we draft any document, we draft prayer, we said to the judge, request the judge, any other relief is possible. We request this honorable judge to grant. So in a very same way, the caseworker has got the discretion, so they can use their discretion in order to grant any anti-clearance or any visa category. This is called outside of immigration rules. I remember once, it was 2014 and 15, I was doing a practice in the UK. It was 21st of December, and most of the time on 21st of December, we closed the law firms till 2nd of January because of Christmas holidays. I received a lady, she was from South Africa. Because of data protection, I not disclose the name of anyone. She popped in and she said, Mr. Ali, I need to file a case. And my manager told me, Mr. Ali, This is the second or third time this lady has come, and she has no documents at all. I asked her, okay, I'll give you 2 or 3 minutes, you can come. She popped in, and she said, Mr. Ali, I have seen my God in my dream, and God told me, you have been living in this country for the last 20 years without any visa. It's a sin. You need to apply. I asked, where are documents? She said, I have no documents. With your passport? No passport. When did you enter in this country? No history at all. I said, then how on earth I would apply and Home Office would give you further leave to remain? She said, I don't know about it. What did I do? I asked my receptionist, can you please note down her statement and become a witness? We had no history of anything. We just filled the application form and we applied. Surprisingly, after Christmas, when I finished my holidays, it was 4th of January something, I received a letter and I thought, we have received now a refusal letter. And to my astonishing, we got further leave to remain. And caseworker has written, I have granted you outside of immigration rules. So this was just an example which I quoted in order to flourish you up. That this is how sometimes caseworkers use their discretion outside the immigration rules. Now let's move to the impact of already seen. The way we have case laws in this country, in a very same way, case laws plays very important part in UK immigration laws. The early decision is very important in the history of UK immigration law because early decision defined the mandatory requirement, including the evidential requirements, that must be contained within the immigration rules. You know what does it mean? Before this rule, in every second case, the Home Office would say, you have applied this, we were expecting that thing. You have provided this, we are expecting that thing. But this decision basically should bring the caseworker. Whenever we receive nowadays any refusal, we can straight away challenge to the Home Office that, look, under the early decision you are bound not to ask those documents which are not required. So keep in mind this early decision. After the lecture, at the end of lecture somewhere, I'll tell you how to file, how to address the refusal, how to handle the refusal, how to file an appeal. So this early decision gonna tell you, it's gonna help you how to file an appeal. So keep in mind this early decision. Using the immigration rules in practice, it's very important for a lawyer to navigate the immigration rule by themselves. How they gonna navigate? Not in the Google, straight away go to the gov.uk web page. You'll straight away get all the immigration rules, or wiley.com. The most important is gov.uk web page. You're gonna get all up-to-date immigration rules on this web page. Now let's move forward to old and legitimate expectations. All of you are professionals who are sitting here. There are some students as well. We have heard retrospective effect of any rules. The same way we have retrospective effect of old rules. For instance, nowadays we have about 200 million immigrants that enter in the UK in the last 2 or 3 years. It is called Boris waves. We have nowadays shortage of housing, shortage in NHS, and shortage everywhere. It's another story. There's no point to discuss about politics. However, there are lots of people who are in the UK on skilled immigration routes. I'm quoting an example in order to come straight away to the point. For instance, if A has entered into the UK on skilled immigration program, and at the point of entry, he was promised to the guidelines that after spending 5 years, you're going to get straight away indefinite and thereafter British passport. But now we have a new government. New government is saying that, look, you have to earn indefinite and nationality after 10 years. So what's going to happen with those people who were already in the UK? What is their fault? So this is the answer of their question. Lots of people are here who will have the relatives in the UK, and they would be worried because of the new rules, because we are facing and we are receiving number of what it is called the queries about these issues. So these rules are important. So I would like to ask you to focus on BAPO Action Limited. This case was brought by BAPO Action Limited, a company from the British Association of Physicians of Indian origin, on behalf of junior overseas doctors who had been encouraged to come to the UK by assurances of career here, but who, after arrival, were denied the opportunity to apply for employment. This case has been decided BAPO in the favor of applicants. And the second one is on the application of HSMP Forum Limited, 2008. Bench judge held that the promise had been made to the individuals at the time of application. How on earth the Home Office can deny now the nationality or settlement? And the third one is Alliance of Turkish Business People Limited. These cases are very important for you, for the law students and those people who wanted to initiate their practice as an immigration advisor. And one thing is very important. In order to start an immigration advisor, you don't need to be a barrister or solicitor or immigration advisor from Pakistan. All of you are qualified in this country, and we have a regulator, the local regulator is called Bar Council. You are providing immigration legal advice to the local client who are based in the UK. For instance, if A wants to go on a highly skilled immigration program, you are sitting in Pakistan, there's a confusion if I should be a barrister or a solicitor or an immigration advisor to help him. No, you don't need. You have a regulator in this country, and that regulator is quite enough for you to support you, to help you in order to assist the client. Now, for most important chapter, and I spend quite a lot of time on this category. Why I spend a lot of time in this category? Whatever I explained you so far, obviously it was very important. But I know, being a lawyer, something is more important, and that is, what are categories? If you have a client in front of you, how are you going to handle? Obviously, a client will not come before you to know or learn the stories of UK immigration history. A client will come to you in order to know how to apply and what categories are available. So this area is straight away relevant to you guys. So let's straight away go. We have nowadays skilled worker visa. So these are categories which are open nowadays. I don't know what will be the situation after 1 year. Obviously, as I told you, immigration rules change quite frequently. We can't say what our category is open today. It would remain open after even a year, but these are open nowadays, skilled worker visa. In order to apply for a skilled worker visa, we need to apply straight away to the employer. This is the new category which has been introduced years ago. Before this category, we had Tier 2, or most probably highly skilled immigration program. This category is basically updated version of skilled worker visa. I hope I'm not speaking very quickly. Is that okay? I'm going the right pace? That's wonderful. I need to involve you guys as well. It's not a one-sided story. And I'll give you a full-fledged session for the answering question. You can raise any question once I have completed the session, right? So, in order to apply for a skilled worker visa, you need to find an employer. How to find an employer? Straight away go to the Google, right? We have Indeed.com. We have different websites in the UK. Straight away apply to them. They're gonna send your CVs or your client CVs to the potential employer. The employer will conduct interview to the online, and thereafter, where you can apply for your client. Where your role gonna involve in skilled worker visa. A client has secured sponsorship. Obviously, it is your job to complete the application on the client. It is your job to know what are categories, what are available. It's your responsibility to navigate the rules. It's your responsibility to know what are guidelines for a skilled worker visa. The guidelines nowadays is they are expecting a very minimum threshold for English language requirement. On top of that, they are expecting some sort of past experience. These are requirements for embassy, not the employer. There are two requirements. One is called embassy requirement. The second one is called employer requirement. So you need to fulfill both of the requirements. And if the visa has been refused, you have completed an application of A for the sake of arguments, and it has been refused. What you gonna do? Obviously, you challenge them. How? And who gonna challenge them? This is you who gonna challenge them. You know what is the fee of challenging the Home Office? It's in hell of payment. You can charge in thousands of pounds. For instance, if you are taking a Home Office in judicial review, nowadays barristers and solicitors are charging over £5,000 in order to take to the Home Office to the courts. And especially for administrative review, you can easily charge £2,000 or £3,000. It's entirely up to you whatever you want to charge. The purpose of telling you about the charge is just to give you an idea. And one thing is more important, please do not charge too much from your clients. You'll earn money, but you can help people as well same time. The next category is high potential individual visa. As the name suggests, it's for those people who are graduated from global universities. There's a list of global universities on the website of the Home Office, as I told you, gov.uk. You can find it, the name of universities, those people who are graduated from those universities, they can straight away apply for this visa. Then we have scale-up visa, global talent visa, innovative founder visa. I'll focus on those categories which are relevant to the Pakistani background, or where most of the people are applying. So let's go to innovative founder visa. Innovative founder visa is a very beautiful visa category which has been introduced by the Home Office. Basically, the requirement of this visa is individual must have an idea of innovative of nature. Innovative of nature does not mean you are going to tell to the Home Office, I'm going to develop a very high-profile jet engine. No. We had a local restaurant, I'll not name for a reason. They started Matka Chai a few years ago. They started what? Matka Chai a few years ago. And it was innovative for the Home Office because we never had a Matka Chai in the United Kingdom. And they were being granted innovative founder visa on the basis of Matka Chai. In a very same way, we have a number of things in society which falls in innovative founder visa category. And that idea must be innovative of nature. It's important for you to understand. Secondly, it must be best interest of British nationals. Thirdly, it be viable and scalable. And one beauty of this visa is, after 3 years, you'll straight away get indefinite. If any one of you has got an idea what is ILR or indefinite, if anyone has come across, please, where is Zen? What is in the ILR? ILR is basically indefinitely to remain. And after ILR, you can straight away apply for British nationality. The beauty of this visa is, after 4 years, you can become British national. Let's move forward. Intra-company transfer visa. As the name suggests, intra-company transfer is for those people who wanted to transfer their company's employees from one place to another place. So this is called intra-company transfer visa. We missed one category. It is called sole representative visa. We had sole representative visa, but nowadays it is with a new name. I forgot the exact name, but we call it formally, it is called franchise visa. We call it basically corporate immigration. Let me explain you. There are some categories within this domain, and they are basically within the domain of corporate immigration. There's a difference between corporate immigration and individual immigration. If a person is moving with the family to the UK, we call it individual immigration. If a franchise or a company is moving in the UK, we call this corporate immigration visa. Anyways, now let me tell you what's franchise visa. I myself, when I was doing a practice, settled lots of franchises in the UK, and they are doing really good. Let me tell you one more example in my real life. We had a company from Faisalabad. They were basically producing clothes and ladies and gents clothes. We had Eid days. My sister and my wife told me, can you please take us to purchase some clothes? I said, okay, let's move forward. I took them after spending, as the ladies are important, the ladies are quite peculiar, to spend 4 or 5 hours and purchase nothing. Sorry from ladies, I'm not prejudiced from any gender. Anyways, after spending 4 or 5 hours, they asked me, there's one shop, can you please take to us? And you know, what was that shop? It was that shop which I established as a franchise in the UK. I never told them. After doing the whole shopping, I requested to the receptionist, where is Brother Arif, who was the owner? And he called straight away, and Mr. Arif told him, Mr. Mansoor, are you at our shop? And I said, yes. And he said, please do not pay. And I said, no, I'll pay. Because I told you I'm here after doing the payment. Because what was the most important happiness that moment for me? Because it was the plant which we seeded, and it was that franchise in Manchester area which crossed the whole brand in 5 years' time. It was a pride moment for me, not only for me, but for all of our community as well. And then I told to my wife, look, this is the franchise we established. So this is the example which I quoted from my personal life. Then let's move forward to study and student-related visas. I would request you, whenever you have come across to your client, straight away determine the merits of any application. Do not pick straight study visa and visit visa. In Pakistan and other developing countries, I have noted that immigration law is equivalent to study visa and visit visas. This is not the case. When we fell ill, we go to the doctor. When we go to the doctor, do you think for every headache, the doctor would give you paracetamol? Do you think they give you paracetamol? No.
Sometimes they're going to give you different medicine. So we have to give medicine according to the background of a client. If a client has a good CV, straight away go to innovator founder visa. Straight away go to any other category. Why visit visa? Why student study visa? Visit visa and study visa, they are not switchable. After doing some studies, you can get 2 year indefinite leave to remain, but end of the day, you're gonna go for skilled worker category. Then instead of going all the way around, why you are not going straight away for that category where you are falling? So I would suggest you do not send your client on visit visa and study visa. If yes, they originally wanted to go on a study visa or a student visa, then yes, straight away send them. Otherwise, do not send them. There's a report to the Home Office nowadays that there are certain countries, I've not named them, they abuse student visa a lot. They said they have sent their students and after they apply asylum. I suggest you, please give a good name to your country. On your country always. And send those people who would become true ambassador of your country. And you are the one who are going to help the people. And you are the one who are going to send the good breed to your, from outside your country. Let's move to visit visa a bit more, because lots of people are having issues in visit visa. We have lots of visit visa categories available nowadays. The most important is standard visitor visa. Then we have business visa. Then we have visa for black purpose. So these are the categories. What documents are required? I'll tell you roughly, because of time duration, shrinkage of time duration. I have just 2 hours, and I have to focus whatever is important. I have to finish the whole course as well. So I'll not spend too much time on nitty-gritty and the requirement, but we'll have a separate lecture sometime where I'll tell you how to do it. And can you move forward, please? Family member relationship route. Family member relationship route is for spouse visas. For instance, A has got married. A is a British national and wanted to bring his wife in the UK. This category is for those people. And one thing is important. A should have a threshold of about £99,000 in the UK in order to sponsor a spouse. And as far as concerned about the requirements for the spouse, the spouse should have minimum English language requirement. That's about 4.5 something. I'm not sure about it, but they must have a minimum requirement about English language. And parent visas and child visas. As far as concerned about parent visas, those people who are settled in the UK, they can bring their parents. If there is no one here to look after them, this is a very important category, and their parents are eligible straight away for all the state benefits in the UK. Let's go for humanitarian protection routes. This asylum route, please do not suggest your clients go on a student visit visa or student visa and apply asylum. No. We have a strong study. We have very strong guidelines. The Home Office website, which states Pakistan is a stable country. Pakistan is, sorry to say, not Afghanistan or Iraq, where they would give straight away asylum. I'm sorry. If you have a really asylum category, or like the Thaf Hussain has been granted asylum, so apply asylum for them. But in every second category, please do not apply asylum for your clients. Now, let's move forward. UK immigration code and hierarchy. As we have different codes in Pakistan, we have district code, we have high court, we have supreme court. In a very same way, we have immigration UK code hierarchy in the UK. Yesterday I was discussing with my brother, with my colleague, Sadar Tariq Saab, and he was asking me, as he has done his LLM from England, and he has done a number of years in practice in England as well, and he was asking for me, in what category we can apply for an appeal? Let me tell you, how would you determine if we are allowed to file an appeal or we are not allowed to file an appeal? If you have received a refusal letter, straight away go to the end. They're going to tell you if you have a right of an appeal or you have no right of an appeal. If you have right of an appeal, straight away file an appeal. If you have no right to an appeal, then go to challenge. If you have merits, then challenge to the pre-action protocol notice or judicial review, right? So I'll go to the pre-action protocol notice, how to prepare the pre-action protocol notice practically, because it's a grey area. I have been doing practice for the last 5 years in Pakistan as well. My law firm name is Nexus Law Associates, we are based in Gulberg. And you know who are my clients? My clients are consultants who are receiving refusal letters and they don't know how to write pre-action protocol notice. So this is the grey area for all of you guys. You should know how to write pre-action protocol notice. If you know how to do it, straight away jump in. I'll tell you how to do it. Anyways, let's go to the UK Immigration Code hierarchy. We have first year immigration tribunal, and the role they do basically, they hear all appeal cases. If the Home Office has refused and you have a right of an appeal, for the sake of arguments, a spouse has applied to join her husband and her application has been refused, then straight away you get a right of an appeal, then you straight away go to the first year tribunal, then against the decision of first tribunal, you go to upper tribunal, and one thing is very important. At first year tribunal, you can provide further documents, but when you go up and up, obviously you can't provide further documents. As in Pakistan, at district court level, we discuss evidence, we discuss each and everything. But if we go to a high court level, we discuss error of law. In the very same way, in upper tribunal, immigration tribunal, we basically discuss, different things, not whatever we discuss at lower court tribunal. Then we have Court of Appeal, and the last court for immigration purposes, Supreme Court of England and Wales. And this is the highest court in England. In most of the cases, immigration cases do not go up to the Court of Appeal. So most of the time, they normally settle at first year tribunal or exceptionally to the permission to the court to the upper tribunals. Can you move forward now? Now, practical example of pre-action protocol notice or PAP. Have you ever heard what is pre-action protocol notice? Anyone, please? Anyone from the audience? Mr. Heather, have you heard about pre-action protocol notice? Yes, we have. Then, have you heard pre-action protocol notice? Yes. That's quite good. I'm quite happy. I'm not the alone who is speaking. You people are with me. Anyways, let's move forward. The Home Office has refused your visit visa. Why am I asking visit visa? This is a very basic visa category. Obviously, after refusal of visit visa, you cannot file an appeal. If there is no appeal, then you will challenge the Home Office to the pre-action protocol notice. What is pre-action protocol notice? The way in Pakistan we send legal notice to the third party, we all send to the legal notice. We have legal people. We basically inform the other party that, look, my client is intending to take to the court to take that matter seriously. In the very same way, we normally send pre-action protocol notice to the Home Office. But we have certain rules. And by adopting the certain rules, we file pre-action protocol notice. The way we have civil procedure code in this country, in a very same way we have civil procedure rules in England. Please note it down. Civil procedure rules. As I told you already, different immigration laws. Now we are jumping into core domain, When we are jumping in core domain, you would need something big, that is statute. What is statute? Civil procedure rules. So, we have civil procedure rules, how to do the application protocol notice. Let's move forward. One thing more, in application protocol notice, you need to inform to the client that, look, you have not assessed the case, not the client, sorry, not to the Home Office, that, look, you have not assessed my client case properly. These are the grievances, and by statute, you have 14 days to answer. Otherwise, I'm going to take you to the court. What is normal norm about the legal notice? People do not reply. If you have sent legal notice to any party, what are they going to do? Most of the time in Pakistan, they don't take it seriously. Why? Because there are no repercussions at all. But in the UK, we have repercussions. What are those repercussions? Repercussions are, if you have started frivolous litigation, we have a reverse cost. Reverse cost, if anyone knows what is reverse cost is basically a penalty which normally judges impose in this country as well.
Damages.
Damages, like damages. Not exactly damages are a bit wider word, sir. Sir, I appreciate whatever you have told me is exactly the right thing. I appreciate your assistance. Reverse cost is basically a losing party is always responsible for the cost of winning party. If I've taken you to the court and I've lost my case, the court will ask me, pay the cost of winning party. Therefore, before taking any case to the court, people will start thinking, should I take the case to the court or should I go for a fresh application? So, Home Office will definitely answer your pre-action protocol notice. I filed number of pre-action protocol notice from my Pakistani law firm, and they definitely have answered it. Please do not charge too much from your clients for pre-action protocol notice. Let's move forward. Now I'll go to how to prepare the pre-action protocol notice, because I know you people are going to tell me, yes, we know the history, we know where to find the law, but how to do the things practically? Obviously, I can see lots of faces who are asking this question, and whenever I deliver these type of lectures, their faces normally pose these type of questions. So let's move forward about the practical, how we do it. And one thing more, pre-action protocol notice is not limited to immigration law. I know lots of people are going to start their practice within the UK. They are planning now. I can see one face, that is Heather. Mr. Heather, there are lots of cases where you're going to send pre-action protocol notice. For instance, if you have personal injury case, if you have professional negligence case, debts claim, housing condition, each has its own detailed steps and timelines. So, in every second case, we send pre-action protocol notice to a third party. These are norms. These are part of civil procedure rules. You cannot go straight away and file a case against anyone in the UK. You must have to send pre-action protocol notice. And one thing is important. Our lawyers do not take a case if we have involved any issue related to any country like Canada, like England, like any other country. They do not take a case. You know what I do? For instance, if I'm sitting in Pakistan and something happened with my client who is a dual national Canadian and Pakistani, the first thought is, I don't know about it. Obviously, I don't know about it. What I do, and I would recommend you to do the same pattern. Take a case, hire an expert person in that country through your law firm, and do the case to them. So this way, you're going to get relief, and on top of that, your client is going to get relief. This is how we handle the cases. The world is basically transforming from single practice into a law firm practice. where the world is going to move forward, I would suggest to the bar councils, we have friends who are sitting here, please promote law firm culture. Law firm culture would really help in order to enhance the professionalism. It would enhance the decay which our youngsters are facing. Our youngsters thinking nowadays, either I should come in this profession or no. Honestly, I'm telling you, it's a very beautiful profession. It's a profession of laws. This profession is going to give you respect, freedom. You have no one sitting on your head who would say this, who would say that. I would suggest you, please go, whenever you come in your practical life, go straight away into the law firm. Try to promote the law firm culture. Move forward, please. Move forward, please. Straight away go to the refusal. So, I spent few time on this refusal letter because you have applied to the Home Office. How you will apply to the Home Office, by the way? You're applying for your own visa, not for your applying for the sake of arguments. How are you going to apply? Nowadays, we do not have form in hard form. We have a portal on the Home Office, which basically plays a role between you and the Home Office. You have to do all communication to the portal. Straight away, go for visit visa. I'm discussing now. If you are applying visit visa for yourself, straight away go to the gov.uk web page, create an account for yourself, and start completing application. One thing is the most important as well. Home Office application is in a very, very simple wording, but the repercussions are very high. For instance, they pose a question. Have you ever been to the UK before? It's a yes or no question, but the repercussions are very high. If by mistake you have ticked no, you visited 10 years ago, you forgot it, but the Home Office will take it as that you have hidden some sort of information from them and then puts you a ban of 10 years under Section 320D. So be careful before ticking yes or no on the Home Office online page. So where you gonna apply? gov.uk. You'll create your personal account and thereafter you'll start applying. What you will do? Create your personal account or your client account and thereafter will go. What is the web page name? gov.uk. Now let's move forward to the original refusal letter. Can you go to the refusal letter further, please? Go to the first page. Go up, please. Go up further, go up further, go up further. This is the very basic refusal I'm discussing. Because I have people who have, this is the obviously introductory lecture course, therefore I have picked up very basic refusal. Home Office refusal letter, what this means to you, not related to us. Move forward, please. Reasons for refusal. Straight away, go for reasons of refusal. In this area, the Home Office is going to tell you what are reasons why we have refused you. Go forward, please. Okay, I'll read, then I'll tell you each and everything practically, okay? If you have come across a refusal letter like this, how are you going to handle it? Obviously, we pick issues in every case. For instance, you have a client before you about the transfer of property in normal or family law cases. The client will tell you, oh, I was been fighting with my mother-in-law. My husband is no good. This happened, that happened. Those are all stories. A lawyer would listen to all the stories, but end of the day, on his personal notebook, a lawyer would write, what is the relevant thing? On what grounds I'll apply a divorce case, or there's an eviction matter from property. A lawyer would listen 20 minutes to 1 hour story and then would pick up an issue in a very same way. Whenever you have a refusal letter, either it's innovator founder visa refusal letter or any type of refusal letter, straight away go on the issues, frame issues. Let's go now. I have refused your application for a visit visa because I'm not satisfied that you meet the requirements of paragraph V4.2 to V4.6 of Appendix V. So, where to find these appendix? gov.uk. There's no need to go here and there. Straight away go and read these appendix before going here and there. Then try to do compatibility of this appendix with the refusal letter. You'll come to know where you are standing thereafter. Okay, let's move forward. I note you have previously traveled to the United Kingdom. Slow, please. Up, please. Up, up, up. I note that you have previously traveled to the United Kingdom and with your earlier application provided full details to satisfy the anti-clearance officer. Okay, what's ECO? ECO is called anti-clearance officer. Basically, case worker, when he operates from outside the UK, we say it anti-clearance officer. When he operates from within the UK, we say it Secretary of State, the Home Department, or SSHD. Right? It's important for you. Every profession has terminology. We have terminology in this category as well. So immigration law has their own category. So ECO stands for anti-clearance officer. Whenever you prepare ECO case, please address properly. It is called ECO, anti-clearance officer. This case has been decided by ECO. Okay. Full details to satisfy the anti-clearance officer at that time that you had met the requirements of immigration rules as a visitor. However, each case must be decided on its individual merits at the time of application. We have nothing to do. It's a standard para which he has added, right? So this is not your issue. Move forward. You apply for a visit visa to the UK for 5 days tourism. In order to assess your intentions, ICE must consider your circumstances in your country of residence based on the information you have provided with your application. We have nothing here except one thing, which is intention. Intention is a subjective criteria. It's a very grey area. We have lots of case laws to address this issue. We determine intention through other parameters. We cannot say the intention of this person is bad. Obviously, it's a subjective criteria. However, we have other factors which are correlated, and those factors will determine intention. Let's move forward. You state you are self-employed, earning 12,000 equivalent to £4,000 yearly. You state you spend £2,859.82 per month in support of your application. You have provided your personal bank statement from MCB. However, your bank statement demonstrates credits of PKR this in £31,395.7, which is more than 91% of your stated yearly income in a 7-month period. Furthermore, your bank statement demonstrates debts of 23,304.5 pennies, which is more than your stated yearly expenditure in a 7-month period. Therefore, I'm not satisfied your income and expenditure as you have stated. This undermines the credibility of your application. Therefore, I'm not satisfied you are a genuine visitor. Here he is asking, you are not a genuine visitor. Why? Because yes, he's asking, he's pinpointing about your bank statement. This is one issue. If he's allowed to pinpoint our bank statement, if he is allowed by the parliament or rules or guidelines, Home Office is bound by the statute. The way city is bound by the statute, in a very same way, Home Office is statutory body. They have to follow the statutes and guidelines. If they are bound, if they can ask you about the transaction details, if they can ask you or not, as I told you, straight away go appendix, which I told you. Read the appendix. And if appendix is saying the Home Office can ask, then yes, he's right. Otherwise, not right. By the way, he's not allowed to ask these questions. Move forward. This is first issue. He raised first issue about what? Genuinity. About what? Genuinity. Move forward. Why is it not mandatory for you to provide any documents? Have you seen? He covered himself. I know that you are not required. Why he is covering himself? Because he knows if he has taken me to the court, the judge will ask me, why did you refuse if he was not required? Why is it not mandatory for you to provide in documents or detail each or any credit within your account? The declaration made within your visa application are not reflected in the documents you have voluntarily chosen to provide. Therefore, as a result of the significant inconsistencies between the declaration you have made and the documents you have chosen to provide, you have cased out all the other declarations within your visa application form and undermine the credibility of your application as a whole. So now the issue is about credibility. At first stage, he was asking about genuinity. We have two issues now, right? Straight away, highlighted credibility, genuinity. Move forward, please. You state you are self-employed, earning £34,000 yearly with no other source of income. You state you spend £2,859 monthly. Based on statements made by you, this means you spend your entire yearly income each year. You state the cost of your trip to you personally will be £2,500 and no one else will be paying toward this cost. Given that you spend your entire yearly income, I'm not satisfied that your expected costs are in line with your stated income and finances. I do not find it credible that you would spend this level of funds on a short trip to the UK. When we fill an application at Home Office, they ask a question, how much you are going to spend in the UK? And you have said, I'll spend £2,500 or something. And now he's saying, I'm not satisfied you're going to spend. If he's allowed to say, because he has seen your bank statement as a whole. He told you, these are your expenses, these are your expenditures. What does it mean? Don't you think so? He has gone beyond his boundaries. He has started asking the money trail, like NAB asks from the people I divide for crime practice as well. If Home Office is a NAB, or they are investigatory body, no, they are not investigatory body. Straight away, punch them, creation protocol notice, and tell them that look, you're crossing your limits. You're not allowed to ask the money trail. And one thing is very important. If your client has a bank statement and there's a big amount which has been entered, or there is not consistency, then in your presentation letter or additional information, inform the Home Office that we have received this payment, you have sold the property or this and that. Because when we apply for a student for visit visa, basically we expect the Home Office that we have very strong ties back to home country. So it's important. So this is the whole issues. They have raised objection about your credibility, intention, and third, you have no, I'm doubtful that you're going to spend. What we're going to do, we have sent creation protocol notice. How are you going to send? Move forward, please. Excuse me for a second. Can you go to the pre-action protocol notice, please? This is the standard pre-action protocol notice. There are different samples of pre-action protocol notice. However, this is the one which I normally use in my practical life. So I won't take too much, just 5 minutes more, and thereafter I'll give you an opportunity to raise any question. either related to how to become a solicitor, how to become a barrister, any UK immigration law, or anything, whatever is related to you. That time will be yours. Happy now? That's quite good. Okay, at first stage, straight away go to the VF number. VF number is basically that number which you're going to get from the refusal letter. GF, WF is again the application number. And our reference. Our reference is that reference number which you have or which your office has allocated to the personal file. Then British High Commission, blah blah blah. Where you're going to send the pre-action protocol notice, very important. Do not post to the British Embassy. This is the email address, the Home Office, UK, VIP, AP, homeoffice.gov.uk. Please note down this email address. You have to send pre-action protocol notice on this email address. This is the special email address in order to receive the pre-action protocol notice. This department going to receive the pre-action protocol notice, and thereafter they're going to send to the litigation department. Litigation department going to respond to you. Then, without being prejudiced. What is without being prejudiced, by the way? Anyone can help me, please? So, did you please? Sorry? तासुब। उर्दू में इसको तासुब कहते हैं। असल में मैं जब उर्दू पे आता हूँ, मैं इंग्लिश भूल जाता हूँ। जब इंग्लिश में आता हूँ, उर्दू भूल जाता हूँ। Therefore, I always prefer to use one language instead of two. Anyways, so without prejudice, we always write on the legal notice or protocol notice. Why we write without being prejudiced? Because it's a part of your procedure rules, which says you have to write pre-action without being prejudiced. It's a part of your procedure. We do not write as a norm or as a fashion. Then, dear sirs, nowadays we do not use dear sir or oblique madam, dear sirs or ma'am or something. These are quite old-fashioned things nowadays. Nowadays we write dear sirs. Sirs inclusive both of the genders. Whenever we do communication in the Home Office, we write dear sirs. It's important. Then obviously the basic things you refer to above, blah blah blah. Then brief background history. Can you move forward, please? Brief background history. Why it's important to write the brief background history? Because we need to facilitate the Home Office. Whenever we go to the court, we always work in your capacity. Sometimes as a representative of a client, and sometimes we're a head as an officer of the court. Am I right? So we need to assist the Home Office as well. Although they are not called, they are a statutory body, but at the end of the day, we are not supposed to increase their burden, rather we need to help them. So we need to provide the brief background history, then go to the grounds of pre-action protocol notice, and you move forward. So at first stage, right, as I told you before, straight away highlight the issues. Your issues are your ground. For instance, we already discussed, they told you, we have an issue about your credibility. You know credibility issue, this is your ground. And then your patient protocol notice should be like that. Frame issue, your arguments conclude. Frame issue, your arguments conclude. I focus just on one issue and thereafter go to conclusion, because if you understood the first issue, you'll come to know how to move forward. Move forward, please. In the page 2 or paragraph 6 of the refusal letter, the ECO stated that moreover, I know you have submitted the MCB statement ending 42679. In that statement, I know credits are unable to reconcile. For example, on 8th of April 2025, I know credits totaling £1,395. The documents submitted do not demonstrate how you have derived these credits or how it relates to your status of employment. I'm not satisfied. Your personal and financial circumstances are as stated. This has further undermines the credibility of your application. This is the issue. From where did you take this issue? Straight away from the refusal letter. Now, the applicant, now your argument, 2.1.1 is your argument, keep in mind. The applicant has given the details of all the transactions in the bank account, but the issue has raised the objection on just this one specific transaction. We have provided you each and everything. You have blindfolded on each of any information. Why did you pick up just this objection? In our view, there's no reason to pinpoint one transaction. The applicant follows the guidelines given in Appendix 5, whereas in these guidelines, there's no rule that obligates the applicant to provide the details of every single transaction in the bank account. As I already told you, he's asking to provide the details of bank account. If he's allowed, we have read in Appendix 5 and the rules, and we have reached a conclusion, no, he can't ask you. So we told him, look, you are not allowed to ask about the money trade. This is how we raise objection. We determine or we write our arguments and we concluded. Can we go to the conclusion now? Because we had several issues. It's so difficult for me to go each and every issue, Fred, because of time limitations. I can see on the background, I can smell very beautiful smell of samosas. So it's better for me to finish it earlier now. So straight away go to the conclusion now. Excuse me. Can you go to the conclusion? And one thing is important. Whenever you prepare your application protocol notice, try your level best to include the case laws. Why? Because when you have added a case law, the litigation department would straight away reach a conclusion, this person has capacity and he's going to take me to the court. So it's always important to include the case laws that look, you have made this problem, you have made this objection, but the case law is this one. You have asked those questions, but the case law says this, guideline says this. So try to engage the Home Office with case laws and guidelines. Do not confront the Home Office merely about the facts. Do not say merely, I provided everything. What everything? Straight away go to a specific thing. Conclusion. In view of the above, we would like to conclude that the applicant is within the line of paragraph 2.4 to 6 of Appendix 5. The issue is an error of refusing this application, therefore the application should be granted a visit visa and that the current refusal letter may kindly be withdrawn. We request you to reply application protocol notice within 14 days. Why 14 days? This is basically a statutory time duration which has been determined by civil procedure rules. So please do not give 1 week or 21 days. We have statutory time duration, and that is 14 days. So this is the whole conclusion. If you need a copy to use as a sample, I'm happy to provide of this application protocol notice. And one thing is very important. I always prefer to share knowledge. If you need any help, please ask for me. I'm happy 24/7 to answer all of your questions. This was the whole about UK immigration law. As I told you, this certificate course was basically initiated in order to enhance the capacity of lawyers. However, if you are a qualified lawyer, you want to become a solicitor or barrister or immigration advisor in the UK, that's our main area. I'm basically a trainer for barristers, solicitors, or an immigration advisor. And we provide all this information. We provide all these guidelines and provide tutoring. Our webpage is www.qualifymelegal.co.uk, and our institute name is Qualify Me Legal. And thank you indeed for all of your presence, and I appreciate. I'm quite positive whatever I have delivered was in a position for you to digest and you have understood it. Thank you indeed, and now it's your time. One by one, raise your hand, pose a question. You can pose a question in any language. I can speak Potwari, I can speak Punjabi, I can speak Mirpuri, I can speak Urdu, and I can speak English. Pose me question in any language. Thank you indeed. Yes. One thing is more important. In immigration law, there's involvement of money. But please do not go with short-term goals. Try to. When I started my practice, my father told me, when I was going to India for further studies, my father told me, look, I don't want you to become a very good lawyer or very high professional. I don't want to hear that you have cheated someone. You have done wrong in daily and money matters. In immigration, and honestly I'm telling you, I try my level best my whole life to follow this pattern. In immigration law, you'll come across lots of money matters because it's a highly, highly paid profession. But please do not give bad name to your profession. Do not give bad name to your parents. And one thing more, it's under the code of conduct. We must give integrity, we must be honest, and we must give integrity to our profession and our colleagues. Thank you indeed. Thank you. I have nothing more to say. Thank you indeed. Just give me 1 minute. Let me have a sip of water, and thereafter you can pose any question. Thank you.
Do you have any questions?
Yes, please.
Please.
सर मेरा नाम मोहम्मद उमैर फिलहाल है। मेरा क्वेश्चन ये है आपसे कि अगर कोई बंदा एम्प्लॉयमेंट के लिए वीज़ा लेता है यूके में, तो क्या वो बंदा वहाँ पे जाकर प्रैक्टिस कर सकता है विदाउट एनी लीगल रिक्वायरमेंट?
Let me explain you. अगर कोई बंदा, should I answer in English or Urdu? ये बता दे मुझे. In English. Okay. His question is, if a person goes to the UK on employment visa, if he can do practice or otherwise. Simple answer. If his employer has a background of law, or you have got a certificate of sponsorship from a law firm, then obviously yes, you are allowed to do full-time job in that law firm, plus you can do 20 hours job in any other law firm. Now, we come across two situations as an immigrant, as a lawyer especially. First is immigration status, and the second one, if we can do practice or not. For instance, I would suggest the legal fraternity, if you want to go to the UK, do not go for other visas apart from your own profession. Because if you have a visa for the sake of arguments for grocery store, you won't be able to do a job in a law firm. Because by law, you are allowed to do full-time job in a grocery store plus 20 hours job in the same profession. So how are you going to jump in? First limb of your question I have answered, and the second. In order to practice in the UK, you must be qualified as a solicitor or barrister or immigration advisor. How to do it, let me explain you in 2 minutes time. You don't need to do the whole degrees if you are already a lawyer from this country. I have noticed lots of people, they have done LLB, LLM from this country, and they have started everything again. Nowadays, the things are quite easy. If you're a qualified lawyer in the High Court, Pakistan High Court, you have a license with 2 years of experience, straight away go for SQE1, SQE2 if you want to become a solicitor. Or barrister, straight away go to the bar standard board and apply your eligibility to the in order to become a barrister. They'll ask you to clear some exams, 3 or 4. It's far easy for you to clear 3 or 4 exams rather to do the whole degrees. And very easiest way is to become an immigration advisor. We have an authority, it is called Immigration Advisor Authority, and by passing just a single course, you can start your practice. You can start your own law firm in immigration law even. So I would suggest you should know. The problem is we do not know how to enter into a legal profession. Basically, we go in a different direction and we want to go in a different direction. To try to focus your end goal. What's your end goal? Either you want to do a practice or what do you want to do? It's very important. I hope I have answered your question. You're welcome. Any further questions, please? Yes, please.
Muslims and especially Pakistanis in UK, do the Home Department or the judges involved in immigration workers, are they biased towards Muslims or Pakistanis when they issue visa?
Very relevant question. Honestly, I'm telling you, by law, they can't use biasness. Racism on the basis of sex, on the basis of religion, on the basis of color is a criminal offense. They can't be. We have mayor in London, Saudi Khan from Pakistan background originally. We have recently Mamdani, mayor of New York from Pakistan, mayor of Manchester from Pakistan, Lord Nazir from Pakistan. If we had a biasness in those countries, how we would reach at that level? Let me tell you, if you have a capacity, if you have a talent, no one gonna stop you. Honestly, there is no biasness. It is you. It is your personality. You're gonna stand. Yes, some sort, some places. We have even in this country as well. We sometimes do not accept our neighbor because they have moved from Karachi or Islamabad and vice versa. Yes, up to some extent, it happens in our society. I have been living the last about more than 2 centuries now in the UK. Not even once I've come across any situation, honestly. Thank you. Any further question?
जी सर प्लीज
सर
वालेकुम सलाम।
मेरा नाम मोहम्मद अजनान है। मैं सर आपसे फॉर्म के रिलेटेड एक सवाल पूछना चाह रहा हूँ। जो वर्क परमिट्स या जो भी हम फॉर्म फिल करते हैं और उसमें सर फॉर्म कोई कंसल्टेंट या इमिग्रेशन का एडवाइज़र फिल कर देता है और सर रिफ्यूज़ल उस रिक्वायर्ड एप्लीकेंट को नहीं मिल सकता, यूके बॉर्डर एजेंसी के लोग कहते हैं जी कि आप हमें कोई अप्रोप्रिएट ईमेल जिससे थ्रू आपने ईमेल किया था या फॉर्म फिल किया था वो आप हमें प्रोवाइड करें या हमें कंसर्न लेटर भेजें जिससे हम आपको रिफ्यूज़ल या डिसीजन भेज सकें आपका। तो सर उसको प्लीज़ इस इशू को गाइड कर दें, कैसे आप रिफ्यूज़ल रिसीव कर सकते हैं।
पहली बात तो ये है कि मैं आंसर उर्दू में करूँ इंग्लिश में?
सर जैसे आप
ठीक है। It's important for you to ask your immigration advisor or lawyer to use your email or ask him to create a separate email for this special purpose. This is the first thing. And once the application has been concluded, ask him to provide the link. You know what happened most of the time? If the visa is successful, the immigration advisor or a lawyer would put straight on the Facebook, "Oh, I'm happy, my client got a visa." If it has been refused, they will not tell you even. This is what happened. So how to handle this situation? First thing, ask them to create a separate email. And once it has been concluded, try to get the credentials of that email. Or in some situation, if you have nothing, then there is one way, which is called subject access report. It is called subject access report. Under data law protection, you can apply any history of anything to the subject accessory for the home from the home office. Go to the home office web page, apply online subject accessory report, and home office gonna straight away send it to you. This is the whole answer. Thank you. Any further questions, please?
Thank you very much, sir.
Thank you indeed.
Thank you.
Thank you indeed, Pakistan High Court Bar Association, all senior executives for giving me this opportunity and honor. I highly appreciate your presence, executives and all members who are present there.
Thank you. Thank you, Vice sir. Big hands for Suresh sir. Concluding remarks के लिए मैं रिक्वेस्ट करूंगा एडिशनल सेक्रेटरी सुप्रीम कोर्ट बार एसोसिएशन जनाब सरदार तारिक हुसैन सर. जी सरदार सर.
जनाब सेक्रेटरी हाई कोर्ट बार, एडिशनल सेक्रेटरी हाई कोर्ट बार, वाइस प्रेसिडेंट, सीनियर वाइस प्रेसिडेंट हाई कोर्ट बार, बैरिस्टर मंसूर, or respected member of the bar and students. I am really thankful to the High Court Bar who provided a very good opportunity for learning and especially for the students. और ये हाई कोर्ट बार का कोई पहली दफ़ा नहीं था. हाई कोर्ट ने, इस बार एसोसिएशन ने और हमारी हर बार एसोसिएशन ने हर साल इस तरह के इवेंट करते रहे और इस दफ़ा मैं समझता हूँ कि काफ़ी ज़्यादा ये इवेंट्स किए गए. और जो आज स्टूडेंट्स मौजूद हैं, मैं स्पेशली उनसे ये बात करूँगा कि जब भी कोई आपको इस तरह के इवेंट्स का मौका मिले तो आपकी पूरी कोशिश होनी चाहिए कि आप उस इवेंट में पार्टिसिपेट करें और मंसूर साहब जैसे लोग लर्नर लोगों से आप सीखें. क्योंकि मेरा एक्सपीरियंस ये है कि जो पूरा साल आपको पढ़ने से, किताबें पढ़ने से, किताबें देखने से नहीं मिलता, वो एक घंटे के लेक्चर से आप सीख जाते हैं. दूसरा, सारे जो आज मैं देख रहा हूँ अक्सरियत में स्टूडेंट्स हैं, डेफिनेटली दे आर गोइंग टू जॉइन दिस नोबल प्रोफेशंस. तो उनके लिए मेरी स्पेशल ये एडवाइस होगी कि जो आने वाला वक्त है वो स्पेशलाइजेशंस का है, एक्सपर्टीज का है. इट इज वेरी डिफिकल्ट टू गेट अ गुड नेम इन जनरल प्रैक्टिस. तो आज से ही आप ये कर लें कि आपने बैंकिंग साइड पे जाना है, आपने सर्विस साइड पे प्रैक्टिस करनी है, आपने क्रिमिनल लॉयर्स बनना है, आपने सिविल लॉयर्स बनना है. तो जहां आपका जो भी इरादा है आप उस चैम्बर्स को ज्वाइन करें. और जो यहाँ पे मेरे बाकी दोस्त बैठे हैं, क्योंकि मैं सारा आज अपनी गुफ्तगू को स्टूडेंट्स की हद तक महदूद रखने की कोशिश करूँगा. किसी नए आने वाले या नए बनने वाले वकील के साथ सबसे बड़ी नेकी ये होती है कि उसको ऐसे चैम्बर्स में भेजें जहाँ वो अपनी स्किल्स हैं, अपनी एबिलिटीज़ हैं, अपनी हार्ड वर्किंग है, उसको इन्हांस कर सके. अगर आप किसी अच्छे चैम्बर्स को, अच्छी फर्म्स को नहीं ज्वाइन करते, आप गोल्ड मेडलिस्ट भी हैं, तो शायद आपको बहुत मुश्किलात का सामना करना पड़े. लेकिन अगर आपने किसी अच्छे सीनियर, अच्छे चैम्बर, अच्छी लॉ फर्म को ज्वाइन किया तो जो सफ़र आपने 10 साल में तय करना है वो आप 2 साल में तय करें. और एज अ इमिग्रेशन लॉयर्स, जहाँ पे पाकिस्तान में जितने लोग यहाँ पे काम करते हैं एज इमिग्रेशन एडवाइजर्स, उनको इमिग्रेशन लॉज का 10% भी नहीं पता. 10% तो शायद. आई हैव अ लिटिल नॉलेज अबाउट इमिग्रेशन. आई हैव गॉट अ डिप्लोमा इन इमिग्रेशन एंड नेशनलिटी लॉ. आई गॉट अ 3 सर्टिफिकेट कोर्सेज which are required to become immigration advisors. लेकिन आज जब मंसूर साहब ये लेक्चर्स दे रहे थे तो वो तकरीबन मुझसे भी ऊपर गुजर रहा था, क्योंकि जैसे उन्होंने बताया कि इमिग्रेशन लॉज हर साल चेंज होते हैं. तो अगर आप इस साइड पे इंटरेस्टेड हैं इमिग्रेशन लॉज में, तो सबसे ज़रूरी ये है कि आप बाकायदा जो इमिग्रेशन इमिग्रेशन जो बैरिस्टर्स हैं जो इमिग्रेशन साइट्स पे प्रैक्टिस करते हैं आप उनको ज्वाइन करें। लेकिन यहाँ पे जितनी अक्सरियत बैठी हुई है मंसूर साहब, ये ज़्यादातर इमिग्रेशन एडवाइज़र बनने से ज़्यादा ये इनकी ये कोशिश होगी कि हम खुद कैसे जाएं। हाँ, हमने यूके का वीज़ा कैसे अप्लाई करना है, वो कौन सी कैटेगरी में हमने फाइल करना है, और हमारे पास जो यहाँ पे ज़्यादा केसेस आते हैं वो स्पाउस वीज़ा होता है वो रिजेक्ट होता है, उस पर हमें एडवाइस करें। जब स्टूडेंट वीज़ा रिजेक्ट होता है उस पर हमें एडवाइस करें कि उसमें क्या है। तो माशाल्लाह मैक्सिमम आपने किया है। तो वंस अगेन मैं हाई कोर्ट बार एसोसिएशन को मुबारकबाद पेश करता हूँ कि उन्होंने बहुत एक अच्छा लेक्चर का एहतमाम किया, और बैरिस्टर मंसूर साहब का शुक्रिया अदा करता हूँ जो मेरे दोस्त भी हैं कि उन्होंने आपको बहुत ही मुफीद बेनिफिशियल लेक्चर से आपको रोशनास कराया। और इमिग्रेशन लॉज की मैं समझता हूँ कि जिनको इमिग्रेशन लॉज की थोड़ी बहुत या जो इस साइड पे काम करते हैं उन्होंने मैक्सिमम आपको बता दिया। तो अब आप किसी क्लाइंट को या आप खुद आप अप्लाई करना चाहते हैं, स्टूडेंट वीज़ा के लिए करना चाहते हैं, इनोवेटिव वीज़ा के लिए करना चाहते हैं, स्पोर्ट्स वीज़ा के लिए, तो आपकी कोई मुश्किलात नहीं होगी। तो आप और चाय के दरमियान में ज़्यादा आयल हो गया। बहुत शुक्रिया, थैंक यू सो मच।
जी थैंक यू वेरी मच सर सरदार साहब। मैं कंक्लूडिंग रिमार्क्स के लिए शुक्रिया अदा करने के लिए सीनियर वाइस प्रेसिडेंट जनाब खाबर रियाज कादरी साहब से मुल्तमिस हूँ, सर आप आए और अपने ख्याल कर रहे हैं।
सबसे पहले मैं जनाब बैरिस्टर राजा मंसूर अली साहब का तहे दिल से मशहूर हूँ कि वो तशरीफ लाए और बहुत इंफॉर्मेटिव लेक्चर कंडक्ट किया, डिलीवर किया। इससे बहुत ज़्यादा इंफॉर्मेशन मिली हम सबको। और फिर जिसके तवसत से आप तशरीफ लाए जनाब असद महमूद राजा साहब, आपका भी मशहूर हूँ कि आपने हमें इज़्ज़त बख्शी और आपने इस जो ट्रेनिंग थी और लेक्चर ऐसे कंडक्ट कराने में हमारी मुआवनत फरमाई। और बिलखसूस एडिशनल सेक्रेटरी ऑनरेबल सुप्रीम कोर्ट से तशरीफ लाए जनाब सरदार तारक हुसैन साहब, आपकी आमद का भी बहुत शुक्रिया। और हमारे जितने मोअज़्ज़ज़ मुखला साहिबान हमारी बहनें तशरीफ लाई, और बिलखसूस जो स्टूडेंट्स तशरीफ लाए, और कहुटा लॉ कॉलेज के जो स्टूडेंट्स हैं और फैकल्टी मेंबर्स हैं, एडमिनिस्ट्रेशन है, आपका भी तहे दिल से मशहूर हूँ कि आप तशरीफ लाए और हमारी इस जो ट्रेनिंग थी इसको रौनक बख्शी। और बहुत सारे जो स्टूडेंट्स हैं वो पहली बार यहाँ पे तशरीफ लाए हैं। तो हम सब ने मिलकर रूल ऑफ लॉ के लिए काम कर रहे हैं।